Hello, everyone. Thank you for joining the webinar today. We are going to be talking about how to build a state-specific lease agreement. And I know you are all very excited for this topic. We've had many requests for it. But before we get started, I want to go over just a few things. So the first thing is you do have a few handouts on your side panel. If for some reason you can't see them or download them, we can always send them to you tomorrow. I put them there really as references if you wanted to print out the presentation right now, maybe take some notes by hand, that option's available there. We also have a question box, so save your questions to the end. We will be doing that after the presentation. And of course, as usual, tomorrow we will be sending you the full recording. So even if you miss something, that's okay. You can always watch it later tomorrow and contact us if you have any questions, of course. Now, just to start here, before actually we dive into everything, I just want to say that with talking about something that is state specific, obviously many of you on the call are going to be from different states. So I want to start off with a quick disclaimer here. Basically, you're customizing the lease to your location, but ultimately it's up to you to ensure that you comply with any requirements of your jurisdiction, including any county or municipal laws. So there are sometimes laws that go beyond even just the state, that might be even citywide. So we're going to be covering where things might differ in your state. But at the end of the day, it's always important to make sure that you are doing your research, and just in case there might be something that's particular to your city or county, although it's usually rare. The other thing as well is that this presentation does not apply to properties under rent control. However, some of the presentation does. So I still think it's worth watching even if you do have a property under rent control, because there are some things that are just going to apply to everybody in general. I'm going to actually be doing the presentation today, and I should probably do a quick intro. I actually am the Director of Education here at the American Apartment Owners Association. I'm the one that puts together all these webinars, different experts in different industries. But today I am doing the lease agreement webinar here today. So basically, what I wanted to do with this webinar is go over AAOA's lease form builder. So about a month ago, AAOA launched its lease form builder, which is actually tailored for each state, and it's been reviewed by legal professionals, so it's completely up to date. So one of the reasons why we're using that today as an example is because it asks a really excellent questionnaire to build the form for you. And so even if you don't use our form builder, even though I really think it's helpful and you probably should consider it, it will ask the questions that you'll have to ask yourself no matter what kind of lease agreement you're working with. So let's get started with the lease. So the first thing that the form builder asks you is basically, where is the rental property located? I chose California. We happen to be in California, and many of our members are as well. So we're going to use that as an example, but don't worry if you're not in California. I'm going to be pointing out where it's going to be different in your state. And the way I'm going to do that is not just by talking about it, but you'll see on the bottom right corner of your screen, there will be a yellow star on the slides that are going to be state specific. And that's going to be where you're going to need to do your homework to find out what's in your state for that particular topic. Now, I will go over in general where most states will kind of have a consensus, but again, always look it up yourself just to make sure that you are getting the most state-specific local laws in place. So after you pick you want California, the next question it asks is standard versus comprehensive. So you may have asked yourself this before: do I want to have a 4 or 5 page lease, or do I want a 12 to 15 page lease? And I'm going to say I highly recommend going for the 12 to 15. It's always better to have more legal protection, more clauses that make the lease clearer than to not, in my opinion. Again, it is up to you, but in this case, we're going to go through a comprehensive agreement just because I think and recommend it for our landlords. All right, the next thing is annual versus monthly. This is a huge decision for you as a landlord. It really goes with your business model. You might have always done it the same way. But I do want to point out what's the difference, what's the pros and cons of annual versus monthly. This is really the first part of the decision that you are going to be making for the lease. So month to month has no end date. Basically, what that means is it's automatically renewed each month unless you or your tenant give the other proper notice. Usually it's going to be 30 days in most states, 60 here in California if the tenant has lived in the property for more than a year or if it's rent control. But the forms generator actually tells you the number of days based on the state that is needed for written notice to end. So you don't have to worry about knowing that if you're using the forms builder. Otherwise, you do have to look it up to see. But usually it's going to be a 30-day term to go ahead and end the month-to-month agreement. Now, the other kind is your annual, which is more common. This is where you have your 12 months, but it doesn't have to be 12 months. It could be less than that or more than that. Really depends on, where your area is. Maybe you have student housing. It makes more sense to do 2 semesters, which might be 9 months instead of 12. So whatever it is, it's a fixed term, right? So you can have a set end date. It doesn't have to be 12 months. Now, fixed term ends on a specific date and it doesn't usually require notice to terminate the lease. However, this kind of is changing a little bit in California, especially. And we are going to have an update on California law specifically at the beginning of next year as to how the new statewide rent control is going to be affecting how these terms are actually enforced. But for now, it's still that it doesn't end until there's a notice to terminate. And then at that point, it would end, or it can roll over if you accept rent and you keep the tenant. It usually will default to a month-to-month agreement at that point. So once you've decided this is where you would fill it in on the right on the forms builder. Now, I want to also just point out some pros and cons. So now we know what it is. What is the pros and cons of monthly? Pros, more flexibility. You get to increase rent on a shorter notice. You can change the terms on a shorter notice. Maybe something in your lease isn't working out for you. You can actually change it with the consent of the tenant. 4, you can end the tenancy. This is actually pretty big because ending the tenancy might be in your best interest, even though maybe the tenant may be paying rent on time. What if they're being disruptive, or they are maybe causing damages, or they've snuck in a pet or an unwanted guest for many weeks? Then you could end the tenancy. You don't even need to give them a reason why in most states. The next one is it's good for a tight rental market with upward trending rent. Now, the reason why I say this is because monthly does have the con of tenant turnover being higher, which could mean increased costs. But if you're in a tight rental market, that's not really an issue. You could probably find a line of tenants if you put up a vacancy post and you get 20, 30 tenants wanting to take your rental. You're in a tight rental market and you do have the advantage of increasing your rent if you need to, and looking for new tenants if you need to as well, if you are on a monthly based contract. Now, the tenant can move out on short notice as well. So that's also a con there, because if you aren't in a tight rental market, suddenly you have a vacancy you have to deal with, and you might have to pay for listings. You might have a vacancy where you're not getting any rent income. And so you have to consider the pros and cons, and it really is going to matter where the rental is located. The other one is annual. This is a nice, safe kind of feeling for a lot of landlords. They find that there's a lot of certainty in an annual lease, and the tenant is liable for breaking the lease early and for costs incurred with the vacancy or filling the vacancy. So, they're signing a contract with you, so they're liable for that money. Now, just because they break the lease doesn't mean that they have to pay you the rest of the term. Um, Basically, in most states, you have to try to fill the vacancy, and then the tenant is liable for the costs during that time that you had to fill the vacancy. So that's nice because it can ensure that you're going to possibly get that money for that 12-month or whatever period you've set. The cons are is that you can't really change the terms that easily. So each state's going to differ a little bit as to how to go about changing the terms. That's going to be a different webinar, really, in changing terms and amending a lease. But in this case, though, just know that it's not going to be as easy as a month to change those terms. Same thing for getting a tenant to move out. So because it is an annual contract on both ends, they have to pay for it, but you also have to allow them to live in the space unless they are substantially breaking the lease by either not paying rent or something else. So that does get to be a little bit more difficult. Also, you can't sell the rental as easily. So it depends on what type of rental this is. So if it's like a single family home, let's say, it might be hard to sell a rental because now you're limiting the rental to only people who want to have a tenant in the unit. So only investment property owners would be interested in that single family. But it's actually a good thing if you have tenants that are paying on time and maybe you have an apartment building or something like that. So again, depends on the type of rental, what you feel comfortable with. It is nice to know that you are going to get that income most likely, if all things go well, for a specified period of time. All right, so let's move on here with the property address, which is the next part here of the form builder. Now, this is self-explanatory, but I do want to say just real quick that here, other details describing the property, I put in here just an example. What might that be? Maybe there's a shed in the backyard, it's not to be used, or maybe there is some part of the property that the tenants should not access. Definitely included in here. You want it to be very clear in the lease agreement so that if they break the contract, you can actually show that they broke the contract in this way versus just maybe telling them not to use it. So just something to look out for. The next part is parking and furnishing. So again, similar, you want to be descriptive. Now this form builder is going to ask you, do you want to specify it? Yes or no, or yes, include a description. You're going to see kind of me following this theme throughout the webinar is if you can include a description, do it, because it's always better to be clear than not, right? So I think having here even in this parking description that it's a tandem parking spot, just so that the tenant for sure knows exactly what they're getting. And then with furnishing, same thing. Especially with furnishing, I would say you'd want to list exactly what has been furnished. So later, if they damage those items, you can show that that was what you had given them. That wasn't something that they bought on their own. So that can later help with legal disputes. Now, I do want to mention real quick a little side note. In California, furnished rentals can collect one more month of security deposit. Now we're going to go over security deposits in just a bit, and we're going to talk about how that's different from state to state. But if your state allows you to collect more security deposit in general, or in California, there's an exception for furnished rentals, and you have a furnished rental, take it because that may actually equal more damages or more potential risk. Or you may want to just charge more rent. Obviously, you might already be doing that. I like the security deposit idea just because you have more assets there that you're giving that tenant other than just the property itself. So the next part here is landlord and property manager. So the lease has to identify the who, right? And you might think this is pretty obvious, but if you have an LLC or a corporation, make sure that you put that in place here, okay? It's very important. And or if you co-own or have multiple partners in an LLC or corporation, go ahead and add it there. Now, property manager is the next part. And in some states, you're actually required to put this information on the lease. This happens to be the case here in California. That's why it's asking us for it. But I would say, why not? Why not put it in the lease? I mean, you want the tenant to know this is who you need to contact if something goes wrong. And it's in your agreement that this is the person, right? So if you don't have a property manager, obviously this doesn't apply. But if you do, you want to make sure they can get a hold of that person if they need to. All right, the next part is tenant information. So again, we're going back to the same thing. Who is the who that is signing this lease agreement? Now, we have here tenant Jane Doe, individual. We're not doing a commercial corporation or anything like that kind of rental. And we're saying here, how can the tenant be contacted? So that's good just for your own reference too, so that in case you lost your phone, you didn't have their contact info, it's on the lease agreement, right? Now, I get calls sometimes from people who ask us, we have, it's a mom and a dad and, their son, but their son might be 20 years old. And so do we put the son on the lease? And my answer is yes, of course you do. And why? Why would you do that? Do we put the wife on the lease too? Yes, yes, put all the parties that are over the age of 18 on the lease. And why? Because co-tenants are joint and severally liable. So the more tenants you have, the better. What does joint and severally liable mean? That means each tenant that you list here is legally responsible for the whole rent and complying with the whole agreement. So you can legally seek full compensation from any one of the tenants. Should the others skip out or be unable to pay rent, or perhaps break the lease in some other way, even if just one of them has broken the lease, they are all responsible. What that ends up happening in that situation is the tenants are going to be more likely to follow through with the lease because they don't want their mom or their friend or roommate or boyfriend or girlfriend to have to bear whatever it is of a consequence that happened because they couldn't pay rent or because they damaged the property. So I think that's always a good idea. Again, check with your attorney if that is the route you want to take, but so far from what I know, that is a good idea. The next part here is, will any occupants be allowed to stay on the property? And in this case, I would put here any children under the age of 18 or anybody else who might be staying on the property perhaps temporarily. And again, going back to this, if you're going to say yes, list the occupants. Why should we list the occupants? Well, it's a good idea to list them just in case you have an issue with subletting or guests, right? So tenants may have guests that stay too long, and you want to make sure you know exactly who is on the property so that if later you have to enforce your guest policy, that you can say, well, this person isn't listed as an occupant, so therefore they're not allowed to stay on the property. So it's better to list them always. All right, so the next part here is the guarantor, self-explanatory. So guarantor is just like a tenant. You can really think of it that way. They are also joint and severally liable. They are guaranteeing the tenant's financial obligations. So although they're not living on the property, they're basically acting and taking the responsibilities just as a tenant would on behalf of the tenant. It could be a corporation. Sometimes, you might have a company that has corporate housing, but in this case, let's say it's an individual. Make sure though with this, just side note, that any notice you provide to a tenant, let's say they are violating the lease, or you want to renew the lease or change a term of the lease, the guarantor also needs to get a copy of that and sign it. Otherwise, the guarantor is not liable for it. So again, just like a tenant, they have to sign everything. Also, side note, and you guys are probably already doing this because I know you guys are smart, you should also screen a guarantor, right? If they're guaranteeing the lease, run a credit report on them, make sure they're capable, have a rental application, take all the same information you would as if they were a tenant. All right, the next part is option to purchase. Okay, this can vary by state law, but to be honest, if you are looking at doing this, it's probably better to just speak with an attorney and have a separate document for it, because this can actually be a little bit more complex of an agreement than a standard lease. But just real quick, just so you know, our forms builder does give you the option of specifying it in the lease if you wanted to, and you can also specify how the purchase price is determined, if there's a non-refundable option fee or not for the option to purchase, and whether or not they will pay a refundable option deposit, and when they have the option to purchase, and how many days they have to complete the purchase. So this is definitely more complex, typically not part of a lease. Again, I would say look at doing this perhaps in a separate document, That way it is, allowing the tenant the ability to know the exact terms very clearly, and also make sure everything is detailed, perhaps even more than just these questions. All right, next one is paying rent. So uh, the forms builder will ask you how often will the tenant pay rent. Um, it's always a better idea to get paid monthly. It's consistent with most states. Most states usually do like 30 or 60 days for any sort of notices. So if you're on a weekly or 2 week or whatever, how many days for rent payment, I'm not sure why exactly you would do that, but it can make it a little confusing for you to then serve those notices within timeframes that are really based on 30 days. Annual, I do get questions sometimes from landlords saying, my renter wants to pay annually. Well, not that it's terrible because you get the money up front and that's great, but at the same time, if something were to go wrong, it does complicate the issue of then you having the money, they move out, do you return the money? How does that work? So let's do monthly to keep it simple, is what I like to say. And then from here, the next question is, well, how much are you going to charge for rent? What day will it be made? I like the idea of having rent due on the same day every month for all of your leases, because it's going to make it a lot easier for you when you have to go to renew the lease. So I would suggest whatever day it is, just to make it like that across the board if you can, and then prorate it if needed, to get that tenant in. The other part here is, how will the tenant pay rent? This doesn't necessarily matter. I mean, it really is up to you what you want to ask. But I I think, having a mobile payment system is becoming more popular. We have actually a vendor with us that does, they're called Rent Mind Me, and they do a mobile payment system. The nice thing about that, or direct debit, is that the money gets deposited directly, which is actually great for you because it's typically automated. So the tenant doesn't really have a choice unless they remember to cancel that from happening. So that is a nice feature. And it's nice for the tenant too, because they don't have to remember to do it. Sometimes tenants, honestly, they pay late because they forgot. But again, up to you which one you choose there. Notice of rent increase. So how much notice is the landlord required to give before increasing rent? I do not suggest selecting do not specify. This is important. And I think that a lot of landlords are scared to go and talk about the subject of rent increase up front, right? But to be honest, it's actually a lot harder to talk about increasing rent after the tenant's been living there thinking that maybe their rent isn't going to be increased. So just tell them up front. And one of the reasons why increasing rent on an annual basis is good is because you are keeping up to the market rate of rent and also inflation, because your costs eventually will start to go up. And I want to just pause here for a second and just tell you a quick story I heard this week. This lady called in from San Diego, and San Diego and California, it's expensive to live here. And she called in and she said she was charging um, $1,900 a month for a 4-bedroom house in San Diego, pretty much on the beach. And my jaw just dropped. I was like, oh my goodness. Like I can't even get an apartment if I wanted to here in LA for that price. And so basically what had happened was she had had a tenant for so long and had never increased the rent. She's completely clueless as to even how much rent was in her area. So what it's good to do here is just to indicate that this will be something that's happening, and that the notice for it is going to be the legal minimum. Not sure why you would want to specify maybe more days than the legal minimum, unless you're in a state where perhaps it's a low number of days, I guess. But the legal minimum, let's say here, is 30 days is the most common. So I listed out here some of the states where it's 30 days. So most of you on the call are probably have a rental in one of these states. The states not listed have between, yeah, like 7 to 60 days. And then the no statute states are there down below where they don't really say. So then you could specify if there is no statute in your state for that in that case. But either way, I think it's good to say that here is the amount of days that you have if, I'm going to increase the rent, which you should be doing. So the next part here is pets, smoking, and vaping. So first thing is, are pets allowed on the property? So you can choose whichever one you want. I'm not saying here that you should choose no just because that one's selected on the screen. But I want to pause here and say that you can have a no pet policy. That's okay. You can also have a policy where they have to ask you first before they move in a pet, and you can specify what kind of pets, what kind of dogs, whatever you want. Now, if it's an emotional support or service animal, that's completely different. That is not a pet. Your pet rules will not apply to that. We've done 2 great webinars on this topic, so I'm not going to get into it too much, but you can have a no pet policy. Anywhere you are, you can have a no pet policy. That is your right. Okay, next point. You also can have a no smoking and no vaping policy, even for medical marijuana. Again, we did do another webinar on smoking policies. It's excellent, and basic takeaway from that webinar, at least for me and I think for most people, is even though marijuana is legal in many states now, it is still a Schedule 1 drug federally. Also, it is technically not a right for someone to have either a cigarette or marijuana habit of smoking. Now, if somebody does need medical marijuana, they can consume it a different way, such as ingesting it or oils or what have you. So you can have a no smoking or vaping policy. That is your right as a landlord. All right, so the next part is the security deposit. This is a big one because there are 6 state-specific factors that you should look up in your area. The first factor is the amount of the security deposit. Okay, so it's usually going to be between 1.5 and 3 months, or a specific dollar amount cap, or a percentage of rent. Check the security deposit laws in your state. In California, it is 2 months with an additional month if the rental is furnished. But definitely check. Also, there are a lot of states that don't have a limit. That's not to say you need to charge, 10 times the rent. Take a look at what's happening in your market. Even regardless, you don't have to charge the max, but if your rental market does have a habit of doing that, it's a good idea to do it because then you'll have that extra protection should you need it. I know in California, it's pretty common for 1.5 to 2 is pretty much standard. Most landlords won't go under that. But you might be somewhere else where that's not the case, so you also don't want to scare off renters by charging too much security deposit. So just keep that in mind. The next part is held in a separate account. So some states actually require you to hold the security deposit in a completely different bank account. And you have to tell the tenant where it's being held. And the only purpose of that account is to hold the security deposit and nothing else. Okay, so if that's a requirement, make sure that you have that account ready to go to put your deposits in there. And that actually is a pretty common statute across the US. The other one that I found is pretty common, more than I thought, is the interest payment. So not only in these states you have to hold it in a separate account, you also have to pay interest on the security deposit as well, which means that whatever the interest payment is set in that state, when you return the security deposit, it's a little bit more than what they originally gave you, which is kind of crazy, but I mean, it could be less, obviously, if you have to deduct for any damages or cleaning fees, things like that. The other one here is pet deposits. So pet deposits are interesting. They are a little different in each state depending on whether or not the pet deposit can be done separately. So in California, for example, you can have a pet deposit. You can call it a pet deposit, but the pet deposit and the normal deposit still can't be above the 2-month limit. And I think in most states that's the case where the pet deposit can't really be above and beyond what the cap is for the security deposit. But that being said, pet deposits can be returned to the renter. So, if they take care of the property, they should have no, and they have good pets, they should have no problem with paying a pet deposit if it's allowed in your area. Also, pet deposits, when it comes to rent control, is also usually not allowed. So check that out. The other part is advance notice of deductions. So advance notice basically would mean that you're going to let them know before you dispose of the security deposit what is going to be deducted so that they have a chance to perhaps fix whatever needs to be fixed on their own. Or you can do like a move in, move out inspection, which actually is required in some states where you have to go through a walkthrough with the tenant before they leave to basically document any of the damages. And of course, we always recommend taking photos at that point. To be honest, I don't care if it's required in your state or not. This is going to be beneficial for you mostly, but the tenant also, okay? Because if the tenant comes back to you and says, like that's not true, then you can go to the full document where they signed that those were in fact the damages when they moved in, or they have made damages when they moved out, and with the photos that also support that. The other part that's very important is deadlines. So I have a quick story. Back when I was in college, there's a security deposit dispute that my friend had with her landlord, and the landlord did not want to give back any of the security deposit. And my friend really didn't think she had done any damages, and other than the cleaning fee, really, that she was expecting. And so she took the landlord to court and sued her for the security deposit. And the first question the judge says, when they get up, the judge asks the landlord, how many days did it take for you to send Lauren, which is my friend, the security deposit disposition? Basically, the security deposit letter that says what's going to be deducted. And the landlord says 30 days. And the judge just hit her gavel and she said, all right, then this full security deposit is owed back to the tenant. And just like that, the landlord lost the case. She didn't even ask anything else, didn't even question the validity of any of the actual damages that might have happened, just based on the fact that she took 30 days and it's actually a 21-day deadline in California. The judge didn't even want to hear it. And, my friend was very happy about that because, in fact, those deductions were a little bogus. But, that could happen to you. And you might actually have actual damages that you should be getting paid for or should be able to deduct for. So make sure that you're looking at the deadlines in your state. I found states as low as 14 days and as many as 60. California's 21. Honestly, if you miss the deadline, you can get sued for the rest of the security deposit. Make sure you know the deadline. Do not slack off on this. All right, next part is here, will a security deposit be required? So you're going to put that in there. The nice thing about the forms builder is that it tells you on the builder what it is for your state. So you don't have to guess and research it, but if you're not using the form builder, you do. So go ahead and take a look at those security deposit laws. All right, late payments. Here's another state-specific one. So basically with late payments, tenants must pay rent on the date it is due. I know this sounds super simple, but I can't tell you how many tenants don't think this is true, or how many landlords also think that they have to, somehow make an exception for tenants, and that it's not really late if it's just a day. This is the fact of the matter, and regardless of what state, tenants must pay rent on the date it is due. A grace period does affect, sorry for the typo, when late payments can be charged. So if you have a grace period, during that period, technically you can't charge a late fee. Now, this varies by state. What varies? When the late fee can be charged and how much can be charged. Okay, so when it can be charged, it's usually going to be either immediately. So in California, it's immediately. I know I saw a couple states where it was 5 days, 7 days, or so on. Now, even though there's a grace period and you're not charging the late fee, that tenant is still late on rent. So you can still go through with your termination of tenancy if they don't pay the rent, because they're still being late, right? So that's not what grace period does. It really is just affecting when those late fees are going to come into effect. So these states have late payment policies. Take a look if you have a rental in one of these states at what the late payment policy is. Now, California doesn't say like a dollar amount or anything like that. It just says reasonable. Okay, so if you take a tenant to court, let's say you evicted them, and you also want to include late fees in the judgment, the judge is going to look at the late fee and say, is this reasonable? And they may or may not actually include it in the judgment. So it's sort of a gray area in California. You might as well put it in there if you can, but don't necessarily expect to get it if you're in California. The other states are a little different. They might have like a specific dollar amount per day or percentage of rent, or maximum, that you can charge for late fees in a specific month. So take a look at those to make sure you're charging the right late fee. And again, the form builder with AAOA tells you, okay, when it gets to this section, it tells you what the late fee policy is. So you don't have to go look it up if you're using the form builder. But I'm just letting you know, be aware of what it is. All right, the next part here with late payments is, again, choosing here what kind of charge you want to do. If you're in California or a state that doesn't have a policy, you can actually choose the amount, be reasonable. Notice of entry. This is another state-specific one. I always think legal minimum is going to be the best bet here. And here again, the form builder tells you California, it's 24 hours. Just want to say here, in most states, it is 24 to 48 hours, or it might be a little more vague and say reasonable notice, or might not have a policy at all. My opinion, I think 24 hours is great. I think most tenants want to know at least 24 hours in advance that you're going to be there to do an inspection. 48 hours would be even better, just in respect of their own schedules. But a legal minimum is going to be the best case scenario for you, just in case for some reason you really, really have to get there quicker. But if you don't have to, then maybe a couple days might be nice for the tenant. Notice of termination, another big one that varies by state. Legal minimum, again, same kind of thought process here. Probably better to just go with the legal minimum, not more than that, just in case you really got to terminate that lease quickly. California has a very long description on our forms builder as to what the termination is, and to be honest, it's going to change in January because of the new laws that came out. But for right now, it's 30 days notice, or you can evict with 3 days notice if the tenant doesn't pay rent or breaches something else, sexually assaults or commits an act of violence. I definitely want them to get out in 3 days if that were the case. Or if they lived on the property more than a year, you have to have at least 60 days notice to terminate the tenancy if it's for some other reason other than, breaking the lease. All right, more on notice of termination. So in the lease agreement, basically what it says is refer to the code section or in accordance with, and then the code section there. You don't really need to detail it completely in the lease agreement per se, but it's nice to refer to the code section in your state that talks about it so that you're saying, okay, if I have to terminate the tenancy, it will be in accordance with the law. These states here don't consider payment of rent late until X number of days from the time payment is due. So this is an exception here for the late fees slide that I had. I should have probably put it on that slide, so sorry about that. But here are the states that don't consider rent late. So basically, I put X number because the number of days varies. So in a couple of these states, even if the tenant pays like 3 days late, technically the state doesn't consider it late at that point until the 4th day, for example. And that's just an example. Each one of these has a different number of days. So if these are any of your states, take a look. Utilities, who will be responsible for paying utility costs? Again, always better to specify, even if you're going to be paying for everything. Okay. I like that our forms builder actually puts in all of these for you, and then you just select which one you're going to pay and which one the tenant's going to pay. Love it. It makes it super easy here to put that into the lease form builder, and it'll be reflected in the lease agreement and the final lease agreement. I don't really have any opinions here. This is really up to your discretion, what you want to charge tenants for. Maintenance, I do have an opinion about this. I think having tenants' maintenance responsibilities as fixtures and heating is probably a good idea. And the reason why is mostly because fixture is really anything attached to the property, which includes carpets, chandeliers, or anything bolted to the property. It's probably a good idea for them to be able to maintain it so that they're not calling you to change a light bulb. Because literally that has happened to some property managers I know. Okay, so make sure that if you select that, that's in there. Now, sidewalks and grass and garden or other, honestly, that's going to apply more for single family if you do want them to do that, or if you wanted to maybe specify who is going to be handling that, you can do so in the lease, and that might clear things up if you have like a gardening service or something like that. Insurance, I think these questions, actually, this comes from the forms builder again, and I don't really like it that much only because it doesn't include renter's insurance. So you might have to actually go in and manually put in that you want them to pay for renter's insurance if that's the case. I think renter's insurance is great and you can require a tenant to get it. And basically, what that does is if the tenant, their property was stolen or damaged or there was something that happened to it, they can't come to you and try to make a claim against you. They'll go through their insurance and make a claim against their insurance first. And then the insurance will probably pay them out if they have a deductible. I've used renter's insurance myself in the past. I have a coworker here who used renter's insurance recently, unfortunately, and he got reimbursed $5,000, didn't have to talk to his landlord or anything like that. And I think it's fantastic for renters. It's in their best interest and yours, and it's very cheap. I mean, the renters insurance policies, they range between $10 and $20, and it's definitely worth it if something goes wrong. And there's my bullet. Okay. And improvements and signing incentives. So this here is just talking about, is the landlord required to make improvements to the property? This is prior to move-in. Okay. So if you say yes, maybe you agreed that you would change the carpet and you just haven't changed it yet. But it's going to happen when after they move in. Maybe they'll move in and then the next week you're going to have to do the carpet for whatever reason. Make sure that's in there. And then will the tenant receive any signing incentives? So what are some common incentives? Free month's rent, rent reduction for initial months. This is something that happens when you really want to fill a vacancy quickly. Incentives can work, especially if you have a building and you have multiple units that are vacant and you want to get those filled up quick. That's going to help for sure. But at the same time, you don't necessarily need to give incentives to fill vacancies faster. We've done webinars on this, and that's more of a marketing strategy. But let's say you had included incentives, you can talk about them here. And also, if the tenant does breach the lease, those incentives may have to be paid back to the landlord. So it also kind of adds a little extra that, hey, tenant, you're going to get a little bit of a help here with your rent, but again, you have to keep up with everything that is in the terms of the lease. Tenant improvements, this is an interesting one as well. So I think only with landlord's consent is probably the consensus here for most of you on the call. If you were to specify the terms, technically they could say, well, you didn't say I couldn't do this. You only said these things. So it's probably better just to have them run it by you, especially if they might have a very creative idea. You should probably take a look at that before they go ahead and do it. Address. So this is now wrapping up. What is the landlord's address? Why is this important? Obviously, the tenant may need to pay rent at this address. I know some landlords who have a PO box for this purpose because they don't want the tenant to know where they live. I don't think that's a bad idea. I mean, I think it might be good for you to keep that separate and have a PO box or a mailing box wherever in your local area. The next part here is include an address for sending the tenant Notices after the lease ends. Okay, no matter what, even if you do tenant will handwrite this at signing, you have to include this. Why? Because let's say a tenant stops paying rent and they move out in the middle of the night with no prior notice and they're poof, they're gone. How are you going to serve them a legal notice for the money that they owe you? You don't know where they live? Hopefully you collected their social and their information. Maybe you can hire a collection agency to help you find them or PI, but you shouldn't have to do that. So try to get an address from them that's more stable. Maybe mom or dad is usually pretty common. That way you can still contact them should something happen in the future. And maybe verify that address too if you can. The environmental disclosures, this is actually federal. When was the rental property built? This is what our forms builder asks you. The reason why it asks you is because this actually refers to the lead-based paint hazards, which if your property was built before 1979, you under federal law 42 USC 485 2D, you have to provide a tenant with a pamphlet, disclose any known hazards about lead-based paint. So the nice thing about the forms builder is, and I'll show you later, if you select yes to this question, or if your property, falls in that age, then it automatically will put the lead-based disclosure in the lease agreement at the end, which is nice. You don't have to download it separately. But we do have it available for free on our website if you do want a lead-based paint hazard pamphlet and the notice. You can download that right now for free. The next thing is asbestos. So this one actually is prior to 1981. So the tenant has the right to know if there's asbestos. OSHA assumes that all buildings that are older than 1981 do have asbestos. So building owners are responsible for locating where the asbestos are and how much is present. And the landlords must check and follow the standards for monitoring levels and containing asbestos. And they must handle asbestos properly during repairs and renovations. So just something to be aware of in the bigger picture. If you have an older property, you may have some of these hazards. So it's probably good to have an inspection available and provide that to the tenant if you have it. That way you're not in any trouble of maybe a lawsuit or being claimed that you have an uninhabitable rental, right? Which might forfeit the rent in some states. Dispute resolution. So I'm not a huge fan of this section. How will disputes be resolved? I know I say usually it's better to specify than not, but I think in this case it might be better not to specify just so that you have the option open to see how you want to resolve a dispute. Obviously, taking a tenant to court is pretty standard. You guys pretty much know, hopefully not too well, how that goes, but there is mediation and arbitration as well, which are also good alternatives to going through a whole court process. Depending on what the issue is, it might be better to do mediation or arbitration. So for example, just a quick explanation of the difference between the two. Mediation is a method of resolving disputes where a neutral third-party mediator will attempt to facilitate an agreement between the landlord and the tenant. Key thing here, the parties are not bound by the mediator's decision. So you guys could still do whatever you want, but it's more like a friendly handshake, which I like that image there of the handshake. That is really what it is. Arbitration is a neutral third party who will resolve the dispute, and the parties are bound by the arbitrator's decision. They are bound. So that's more of the gavel, more, for sure that this has to be enforced. Now, not binding and binding I put here, but ultimately the big question is who pays? Who pays for the mediator or the arbitration? Now, some counties do offer mediation for free, which is fantastic if you're in a county like that. I know Los Angeles County has really been pushing mediation. They really love it. I know I went to Pepperdine and they have a dispute resolution program and they work with LA County to do these disputes, and it's all free, which is amazing if you're a landlord and you could take advantage of that. But arbitration is usually done by a judge or by somebody who's maybe a retired lawyer or something like that. So you may want to just, think about that if you are going to consider one of the two options. Is it going to be split 50-50 with the tenant, or perhaps it'll just go straight to court? All right, so assignment or sublease. This is actually important, especially now in the day and age of Airbnb, right? Everybody seems to be putting their property up on a sublease, and then landlords suddenly realize it when they go on Airbnb, or maybe a neighbor tells them that people are just showing up all the time at this house. Now, if you want to do assignment, just know assignment is a total transfer of the rights, while the sublease is transferring only a part of those rights, like a shorter length of time or part of the property. So you can't have a sublease where maybe the tenant has a roommate right now and they both are parties to the lease, the roommate moves out. That tenant, if you allow subleasing, could actually have a new tenant come in and lease. Assignment would be if both tenants were to leave the property completely and then they were to have their own lease agreement with new tenants who would come in. It's a little bit of a gray area here as to whether this is a good idea or not. Think about if you want to give tenants that option. Either way, you can require the tenant to do a background and credit check and run it by you, or you can do it only if you approve it. So it could be like a case-by-case basis if you did want to include that at all in the lease. So here it does ask you in the form builder if you want to specify or not, or say yes with landlord's consent, which if you are going to say yes, I would say obviously with landlord's consent is the way you'd want to do it. All right, next part is here, will the tenant have the option to renew the lease? This goes back to now some slides ago where I was talking about rent increases, right? It's a good idea to select yes with the same terms except rent. You don't have to increase rent. Let's say you have an amazing tenant and you want to reward them for being so great and you really want them to renew because you don't want to have to rent to somebody else who you don't know, then you might not want to increase rent. But let's say you do have somebody there, maybe inflation costs went up or you had to repair something big on the property. You might want to have that option of increasing rent. And just because you don't put it in doesn't mean you can't do it. But again, this goes back to what I was saying. Telling the tenant up front is always easier than telling them after the fact, especially if you don't want to lose them. So you may want to select yes with the same terms except rent. The next part here are re-rent charge and keys. So a re-rent charge is typically used in leases that are at least 6 months long to compensate the landlord for the cost of finding another tenant. So you can set a fee. This isn't enforceable in every state. So even if it is in your lease, you may not be able to enforce it. Where maybe you say, okay, if you break the lease, it's $2,000. Technically, in some states, it's not enforceable. The tenant could, refuse to pay that. So make sure if you are going to put this in that it is something that you can do, but also make it reasonable. And also the keys, if the tenant loses a key, do they have to pay for it? I think it's a good idea, right? Keys are usually inexpensive, but if you have an expensive key or a special key that needs to be made, probably a good idea to charge a small fee. Again, keep it reasonable. And inspection report. So we talked about this slightly earlier. I touched on it. Whether a walkthrough inspection should be completed. In some states, it is required. The forms builder will tell you if it's required. But do I think it's a good idea to do anyway? Of course. I mean, you really should go through before they move in or right the first day and the last day or maybe a week before the last day or something like that to go through the rental, make sure everything is nice and clear for the tenant to know what may possibly be deducted from the security deposit. Give them a chance to fix it. Honestly, if they fix it themselves, that's better for you because you don't have to deal with it. So it's better to be open and upfront with it if you can be, so that they have the opportunity to do that and takes that burden off of you. So additional clauses. Now, these are for terms or issues unique to your situation that have not been addressed in the questionnaire. I would put things in here like renter's insurance, for example, is a really good one. And really the reason why you want to do this is just to write your clauses with plain language and limit them to one paragraph in length. It's really all to reduce confusion. Okay, so if there's anything where, a tenant might still wonder, you might want to do a clause. Now you don't need to go clause crazy, okay? Because you can always do a like a guide or like a little handbook for your renter that takes really the highlights of the lease and makes it into a small little rule book or reference book for them. And that isn't a legally binding contract, but it is also another way that you can reduce confusion. So just keep the clauses very simple, and if you're going to add any to the lease, and relevant to the lease. And here, again, if you are going to be writing these yourself, either have a lawyer look at them or look at any predefined terms that you might be using so that everything matches what's in the lease agreement, right? So if they're called tenants at the beginning of the lease, use tenant in the clause, not their name, and so on. All right, so we are almost done. At this point, the form builder has finished. And on our form builder, it gives you the options up at the top. You can print it, you can download it as a PDF or a Word document, you can go back and change answers. You can do the editor, which is very cool. It actually gives you the ability to edit right on the screen and type in whatever you want, which I absolutely love. And I want to point out at the bottom, I know it's a little low, but additional documents, lead-based paint pamphlet, and California bedbug disclosure. Honestly, a lot of landlords don't know in California that it has been required now for over a year to have a California bedbug disclosure signed by a tenant. What's great about the form builder is you don't have to know that. It tells you these are the additional documents you're going to need. And not only that, it includes it inside of the lease agreement. So when you print it, it's already there. It already comes with all the terms that you need. So I definitely think the forms builder is going to be your best bet for having an up-to-date contract, and one that really answers all of the questions and all of the terms that you maybe should be putting in your agreements. All right, so forms, forms, forms. This is just one of 150 plus forms on our website. We did this a month ago. It was a huge demand from all of our members, and I'm like just beyond excited to have this many forms for you. And these forms are really any category: landlord, estate planning, business, financial, what have you. So I highly suggest taking a look. It's $29.99 for 1 month, $59.99 for 12 months. This is the best price out there for something as comprehensive as this. From our research, we have a special partnership. We have legal professionals that are constantly reviewing these documents, and they're completely updated and they're super easy to use. That whole process we went through, that's the process you would go through, basically answering questions really easily and then getting, boom, a fully legal compliant document at the end. And I'm going to give you a promo code tomorrow for joining the webinar today. Very excited to have had all of you on here today. $5 off if you do the 12-month forms. And I really think this is going to come in handy because there are a lot of forms that you don't even know you need until you need them. So you might as well have 12 months of just knowing that whatever you need is going to be there. It's unlimited. Many copies, as many tenants as you have, you can do 20 lease agreements and, however many other documents you want. So the other great thing is that there's no auto renewal on this, because I hate auto renewal. And I was working on this program, and I remember telling my boss, we can do this, but I don't want auto renewal because I hate it when things auto renew that I might not need necessarily. And so definitely, if you get it, you can always get it again if you need it longer, but you don't have to, which is great. All right, so that wraps up our landlord forms discussion. I know I went kind of long, it's already been an hour. And so for those of you who are still willing to stay on the call, if you have any questions, please start to put them into the question box, and I'll go ahead and answer them real quick. Let's see here. Okay, first question, does AOA have these forms for their members? And they absolutely do. So I'm going to go ahead and show you, if you're looking at my screen here, where we have those forms. So if you go to aaoa.com, okay, and you click on landlord forms, okay, you'll see here the full list of all of our forms, which is a lot. These are just landlord. Here are some that are free, okay? I mentioned the lead paint disclosure. You can download that for free. But again, it is included if you do the paid forms as well. And check this out. Look at the other categories. This is really cool. A lot of business ones, joint venture, sales documents, purchasing agreements. You have financial documents as well, which is fantastic. I could go on and on, but I won't bore you with that too much. Take a look at it there on the landlord forms. Basically, you can view pricing and you can choose here one of the either month or the 1 year, or you could do just the free ones if you'd like. All right, so the next question is, if you're in, Sam says, interested in California lease, rent control in California, some idea of giving termination notice. So, Sam, I wish it was more simple than this, but rent control is really going to be different depending on what county you're in. So, I would say it's probably a better idea to just consult with your rent control board in your area. We are going to have a California-based webinar next year, early next year. I'll send you all the invite if you're in California. That's going to talk about the rental laws that are going to be put in place statewide. But even after those laws are put into place, the rent control cities still have their own policies and their own rules still. So you still have to go and look that up. I wish there was an easier way to say all rent control does this, all rent control does that, but it really is each city, and there's a lot of them that have it in California. So you might have to just do a little bit more research for that. So here is from Sam, can we charge a deductible repair cost of $25 to $35 to tenants? So I think, Sam, what you're referring to is like maintenance, for example. So that's also, that you could charge a deductible fee for it. If you want to, you could add that in manually to the lease agreement. Would you be able to increase the annual lease term by 3 to 5% if they do not renew? This is Alicia. This rental increase thing really has to do with where you are. So there are some states that have limits for the entire state. There's only a couple that do that. California for a long time did not have a limit, but it was 10%. And it was like the cutoff for how long you had to give a notice. So if it was under 10%, you could do it in 30 days. If it's over 10%, you can do it in 60 days. So yes, Alicia, in most places you can increase the lease term by 3 to 5%. Increase the rent by 3 to 5%. Actually, 3 to 5% would be pretty reasonable because the inflation rate is usually, close to 2 to 3%. So it wouldn't be too far off if it's in line with your rental market. Jack is asking, when will the lease builder be updated to include a renter's insurance line? You know what? Again, it's not in there right now, but I can definitely see if we can write something for you if you want to plug it in yourself. Like I said, the forms editor has that really great feature where you can actually type in the form and change it to whatever you want. So I'll work on giving you guys something that you could copy and paste into that area. All right, the next one here is Carmela saying, can you send me a link to the handouts? Yes, and everybody on the call, you're going to get the full recording and the handouts. I gave you a couple of good resources. Basuki's asking if the 150 forms are free for members. At this time, they are not. This is an extra service. We do have free forms for you that are general, but one of the nice things about the form builder, again, is just how state specific it is. And so I do recommend looking into getting that just to have the most solid agreements and forms in place. So do all these forms have a form builder or just the lease? Great question, Grant. Every form has a form builder. It is amazing because it's specified for the state that you are looking at, and it asks you all the questions that are related to the form. So you don't really have to think about what needs to be included in it. It asks for you. So yes, the form builder is on every single one of the 150 plus forms. Now, we do have some of the general forms that I was talking about. Those are not form builder forms. Those are the free ones, okay? And those don't have it. But all of the ones on the paid ones do, which is a lot. And then here as well, from Leo asking if you can amend the contract if tenants want to add additional people in the house. Yes, you absolutely can amend it. You would need to get the sign off from the tenant if it's an annual lease, and you can include your policy in the lease stating that if a tenant is to be added, that you would want them to be screened, let's say with a credit and background check. That is optional, but yes, you can add a tenant and amend it, and it can be, as we mentioned in the form builder, upon your approval, right? So you have to approve it to make that happen. Let's see. I saw there another one that says, got rent control, time to move to another state. And I feel you on that. There's a lot of new laws that are coming out that aren't necessarily landlord friendly. All right, so the next one here is Sue just stating that giving rent increases, but giving a discount because the tenant has paid on time might be good. I agree. So maybe you just don't increase it as much, right? Or, even discount it maybe, but, it might be good to not discount it just because your costs might be going up. But again, totally up to you what you want to do with that. Just make sure you check the rent increase laws in your area. Make sure you don't increase it too much if you do decide to increase. But I think a few percentages is not unreasonable. Like I said, most local rates of inflation are usually between 1 to 3%. And so if you increase your rent by that much, let's say you had a $2,000 lease or something like that, it really isn't very much money. It's perhaps maybe $40, $50 or something like that. And the next question here is, Basuki, notice of termination slide, their mentions refer to code section. What code section is it? Is it in the contract, county, city, or federal? So Basuki, yes, the code section is actually going to be statewide. So you can look up your state and look up notice of termination to see what the code section is for that. In California, I'm blanking on what it is, but it's automatically included by the forms builder. So if you're using the forms builder, it just puts it in there for you. If you're creating it yourself, then just go ahead and make sure you go online and you can just type in code section for notice of termination rental. You usually will pull up the exact legal language and you can just reference that specific section. All right. And the next one is here for Michelle. Is there a way to send contracts through email and print them? Sorry if I missed this. No, Michelle, that's a great question. I don't think I mentioned that. You can download it as a PDF and then have them sign it and send it back to you. If you have like Adobe Pro, you can have a signature section, but I know a lot of people don't have that. They might just have to print it and like do it by hand, but definitely you can just email it to them after you use the forms builder, which I'll go back to here real quick just so you can see what I mean. Right here where it says download, that's how you can do it or print. But if you could download it and you can email it to them, attach it to an email. And Raul says, do you need to be a member of Bigger Pockets to have access to buy the forms? No, Raul, you don't need to be a member of anything. You don't even need to be an AOA member. You can just buy the forms access. So it's 30 days or 365 days, whichever you prefer. And you don't need to be a member of Bigger Pockets or of really our association either. And again, I'll send you the link to where you can access our forms because I know I went to the website real quick to show you, but I'll send you the direct link if you guys want to do it, along with a $5 promo code, the full recording and everything. Let's see here. Michelle asking more about our benefits of AAOA. There's some great benefits as well, which is mostly with tenant screening. You can get 2 free tenant screening reports every year, $10 off tenant screening. Every single webinar is going to be free. So typically we charge $25 per webinar, but in this case, we are doing this all free for you. It is a special offer because we are trying to really draw attention here to our new forms builder, which I think is just fantastic. And so we've decided to just do this all for free for you and also do a $5 off coupon as well for those of you who attended today. But Michelle, if you want to call us and ask, our phone number is right here. I'll show you real quick. So right here, live customer support. If you want to just write that number down, We have so many people here who are just awesome to talk to. I even answer the phone sometimes. Give us a call and we can explain to you more about membership benefits and specifically how they can benefit you. And Robert here is asking about the bed bugs form. Do they need to sign the new form? Yes, Robert. Go ahead and download that form. It is free and have your tenants sign it. That form is available here under free forms. Let me come up here. So you see where it says free here on the website. It is here, California bed bugs form. Go ahead and click there to get an instant download and have any of your current tenants sign it as well. All right. Oh, Michelle, if you don't see the number, you know what? Let me just type it in here to the box for you. I'm going to send everybody our phone number real quick. If you guys have questions about the forms, just call that number and talk to somebody here or about our membership. We can give you more details about it. Okay. You're welcome, Michelle. And for those of you that are still on the call, thank you for making it this far. I know we went over the hour that I had stated, but I hope it was worth your time. Please take the exit survey. I'd love to know what you thought about this webinar. We are having another webinar, which is being sponsored actually. If you go to education and click live webinars, this next webinar is going to be in 2 weeks. I am really excited. We haven't actually done anything about Delaware statutory trust yet. So if you're a real estate investor, you want to learn more for free, this is another free one. We hardly ever do this, but I really am excited for it. Go here to register for the 1031 exchange and Delaware statutory trust. K Properties Investments has done a couple webinars for us. Those of you who have been on those know that they are really good. And not only are they good at what they do, they're very good at explaining it. So even if you don't use their services, they'll be able to explain to you how Delaware statutory trusts work. Is it right for you? Should you do a 1031 or not? I think this is going to be very enlightening for those of you who maybe don't know a whole lot about it. It could be an option for you. So again, register here for that. And I'll be in touch with you all tomorrow. Thank you so much for being on the call today. And I will be seeing soon, hopefully. Take care.